Greetings, everyone, and welcome to the series of quick and honest interviews presented by the East European Dispute Resolution Forum, the EEDRF. My name is Artem Doudko, and I will be asking the questions. And our guest today is Noah Rubins, QC. I'm sure that most of our viewers already know Noah. However, we'll mention a couple of items from his biography by way of introduction. Noah is a partner at Freshfields and heads Freshfields International Arbitration Practice Group in Paris, as well as their global CIS Russia Dispute Resolution Practice Group. Noah has practiced law in New York, Washington, Houston, Istanbul, and Paris. He speaks English, French, and Russian fluently, as well as having working knowledge of Spanish and Hebrew. Noah, welcome, and thank you for joining us today.
Happy to be here.
Excellent. Our technical topic today is focused on cross-examination and is described as getting the best out of cross-examination and knowing when to stop. However, before we move to the technical topic, our viewers would like to find out a bit more about you as a person, if that is okay.
Sure.
Brilliant. Just to set the scene, obviously this interview is organized to support the East European Dispute Resolution Forum. And I understand that you attended one of the earlier events in Minsk. What was your impression? What made it different? Would you come back again?
I'm just waiting for the opportunity to come back to Minsk again for the EEDRF. The one that I attended most recently was the topic of experts and expert testimony. And having a single focused topic like that over the course of a couple of days gave a deeper view on some of the really hot issues and really difficult issues in relation to expert testimony. And I was really impressed by the active collaboration of all the people in what was a pretty big room. I thought that the level of discussion was higher than most of the discussions you have at these conferences.
Yes, that was definitely differentiating, focusing on one particular issue of dispute resolution. But I also found the program of bringing everyone together, the networking opportunity and all that was really good as well at the DRF. It really, Alexander and his team really put a lot of effort into that.
Absolutely, and the social events were amazing. Not to mention, I mean, the location in Minsk. People, I think, who haven't been to Belarus before don't know how interesting and beautiful a city Minsk is. And the location of that hotel on the river, I just remember my morning runs along the river was just stunning.
Very good. And obviously, mock online hearings are not that far dissimilar from real online hearings, of which I've definitely done a few over the last year. I'm sure you have as well. How do you think having the virtual hearing has impacted on the skills required of an advocate?
It's a good question. I was very skeptical about virtual hearings, and the first couple that were coming up as real hearings, and the question arose, would they be postponed or would they be held virtually? My side opposed. Then one of those oppositions was refused, and we had the virtual hearing imposed on us, and I started to understand that actually there's not a huge difference. There's some slight positive differences and some slight negative ones. The positive one is there's an opportunity to see in a way that you can't see in person. Generally in a live hearing, you're sitting between, say, 2 meters and 3 meters away from the action. That is to say, either the witness, usually that's more like 2 meters, or the tribunal, which can be 3 meters away. And here, the faces are potentially right there. And so you can actually see better the reactions of the people in the room. Now, you can't see everyone in the room, and that's one slight disadvantage, because often, you'll be scanning opposing counsel to see their reactions, and that's a little more difficult. But in any event, it does require a different kind of skill of observation, because you need to be concentrating what you're saying and then scanning these little windows, particularly the tribunal, in order to gauge their reactions. But potentially, that makes that observation, that very key element of advocacy, it makes it easier. One way that I think virtual hearings are a little difficult is in the treatment of witnesses in the sense of working with documents. So in the old days with real hearings, you generally had one of your own associates or paralegal sit with the big bundle, and sometimes that could be 10, 20 volumes next to the witness.
Could be more. Yeah.
Could be more. Sitting next to the adverse witness, and literally just she knows in advance what's coming up. She pulls the bundle, she opens up the document, she lays it in front of the witness, and the witness just works with that document. That has, as in my experience, is not happening in virtual hearings because everything has gone electronic. And so it's expected that the witness will sit there and just see on the screen, will see the document that's necessary.
Mm-hmm.
Now that creates a bit of unfairness for the witness, in my view. We always tell witnesses in advance of a hearing, if you're shown a document, don't answer right away. Take the time to flip through the document. Do you recognize it? Do you remember the context of it? Look before the part you're directed to. Look after the part you're directed to. And somehow when there's a screen, this is, again, it's the psychiatry of, I won't even call it psychology, it's the psychiatry of screens. The witnesses just go, and their brains turn off. And I see a screen, I am going to look at what's on the screen rather than saying, could you flip a page back? I'd like to refresh my memory.
That thought probably wouldn't even occur. There is you can ask for a flip back or a flip forward.
Of course. Technically, they don't want to make trouble. Maybe it's difficult to do. If they could do it, they would have done it, right? So I think in future, there's going to have to be something to accommodate a hard copy that can be easily manipulated by the witness. For now, that's not there. So those are just some reactions. On the whole, I'm very happy with the virtual hearings. I love the fact that you don't have to travel for the hearing and you go home to your family after the hearing is over. That's wonderful. You can also immediately be in your infrastructure if you're able to be in the office, of course, which we have the luxury in Paris of being able to be in the office. But yeah, there are some great advantages to it.
And I mean, you've already mentioned the document side of things. Any other ways that virtual hearings have specifically impacted cross-examination? Because that's obviously our key topic for today's discussion. So how have you seen virtual hearings impact specifically cross-examination?
I actually saw fewer objections. And I think that's because you have to click on unmute, and people are reluctant to do that. Again, we're conditioned in certain ways to deal with technology.
Mm-hmm.
I'm not saying that objections are particularly common in international arbitration, but I've sort of seen on our side sort of doing some things that are a bit close to the line on purpose, and something that I might have objected to if I were the other side, and it doesn't come. By the same token, I feel myself sort of resist the temptation. I could do it. Nah, I'll let it go. And so I think there's more of almost a webinar flow to it, right? Where there's just the two, it's just the witness and the cross-examiner and going back and forth.
Do you feel that you're more rigid in the way how you interact to focus on the most important questions, keeping it as simple as possible just to get your point across?
I hope that I do that all the time. It is so important, and as we'll probably get on to, it is the core of what good cross-examination is about. For now, I haven't seen in opposing counsel, for example, any particular difference of better or worse cross-examination, more or less focused cross-examination. I've seen rambling virtual crosses, and I've seen focused ones. So no, I don't think I've noticed that. It may be, but I don't think I've observed that.
I think the one thing I've seen is where advocates are in person known to be very, I don't know if theatrical is the right phrase to use it, but it's a performance. There's the emotion, there's the gesticulation, and I see a lot less of that in the virtual hearings that I've seen.
I'd agree with that. I think there's a certain level of sterility to it, which may not be a bad thing. And if someone is really intent on having a bit of theater, there's nothing stopping them from doing it. It's just the psychiatry of technology.
Mm-hmm.
And when they're staring at a camera, to be somewhat clinical about the way that they present.
Yeah, psychiatry of technology. I think you should copyright that. It's a new, it's a Rubinism.
I give it to the public. It's public domain now. Someone write an article.
Have you seen clash of cultures taking place in a virtual cross-examination so far?
I think more to the contrary. It seems to level the playing ground, the playing field a little bit. And again, people tend to gravitate towards a certain mode of presentation when they're on video. Not sure why that is, but no, I mean, you always see a clash of cultures. There are different styles, there's different legal baggage, particularly people who come from different litigation backgrounds will carry that naturally into arbitration. And I don't see that, going away, but I don't see it increasing with the use of virtual.
One of an examples of this could be the approach of English counsel to use the phrase of "I put it to you," that which we often hear in cross-examinations. What do you think of that as a mechanism?
It has its very narrow place, right? That "I put it to you" comes from a 19th century case called Brown and Dunn, and it was a case about fraud. And the whole idea was, if you're going to accuse a witness of lying, you should at least give the person the opportunity to answer the accusation. That's sort of it's not fair to sort of slip it in afterwards if you didn't give them the opportunity to say whether it was true or not. Right? I think there is some merit to that, but we also have to keep in mind that in the litigation context, in English litigation context, trials are weeks long, and there's unlimited really time to ask whatever questions you want to ask. And so with every proposition, there's the luxury of saying, "Mr. Jones, isn't it true that you're an abject liar?" And Mr. Jones says, "No, it's not true. You'll never find a more honest man." Okay, well, that was an inevitable exchange, right? Do we really need that? Did it really advance the ball at all? Well, from a perspective of fairness, at least you got the opportunity to deny it. Now, unless you're in front of a very English tribunal, one composed not only of English practitioners, but of former judges, I think you will tend not to find any expectation that the Brown and Dunn rule would apply. And I don't think that it's particularly effective in front of civil law judges at all, who tend to disbelieve witnesses perhaps more than others anyway. And I think it can be counterintuitive and counterproductive, where what you're trying to do all the time is only ask as many questions as you need to ask, and you don't ask more than that. And for example, from an American perspective, where there is no Brown and Dunn, an American litigator would say, "You never ask the witness that last question. Aren't you? Doesn't this all mean you're lying?" But why would you ever ask that? You've set it up so it's obvious he's lying, and let the jury decide. And the jury doesn't want to be told whether he's lying. They want to come to that conclusion themselves. And so just leave it there. And otherwise stated, don't tell them it's 4, just say 2 + 2 =. That's it. And then stop.
Well, that was one of our the topics of today, is when to stop. So that's really good tip there. But you mentioned obviously the English tradition of longer hearings, say in litigation, which sometimes also happens in arbitration, as compared to the European tradition of perhaps shorter hearings. Which do you think is better, having shorter hearings or longer hearings?
Well, I mean, you could imagine how expensive arbitration would get if we had 6-week hearings, right? We've gotten to a point where, I don't have the sense after a 2-week, a 10-day hearing that we needed another 2 weeks, right? Now, maybe that's because the work expands to fill the time allotted, maybe. But I tend to feel that, particularly with the most typical length being either 5 or 10 days, depending on the complexity of the case, that after 10 days, everything has pretty much been squeezed out. Now, there are unusual cases where there are 20 witnesses, where there are 5 experts, And there are so many legal issues to explain that 10 days is not enough. But rare is the case, I think, that really needs more than 10 days. And as an arbitrator as well, I think I would be surprised to find that any case it requires more than 10 days to hear it.
And I mean, I agree with you. I think there are exceptions, of course, but generally a week-long or a 2-week-long hearing should allow you to go through even some pretty complex issues. And that leads me to the question about, even if it is a 2-week hearing, one of the key difficulties I think that advocates face is keeping the attention of the tribunal. Any tips or suggestions on that front from you?
Well, there are some simple ones and there are some more complicated ones. I mean, the most straightforward piece of advice that I give people is speak in human tongue. Speak with feeling, not with theatrics of, like waving your arms around, jumping up and down, imitating various accents. No, I just mean speak the way human beings communicate to each other. There is nothing more sleep-inducing than someone who sounds like they're reading an encyclopedia off the page. And there's no reason to do it. There's no particular vocabulary of arbitration. And indeed, because it's so international, the only way that you can be sure that your sense is conveyed is to be sure that the way you speak is the way, in basic terms, human beings communicate with each other. I think that already goes a long way, because if someone understands where you're going and you have a good point, they will remain engaged. And that means also intonation. That means making sure that your voice reflects what you're saying and isn't just sort of flat. And that is the harder thing, which is you have to move gradually in your career away from reading scripts. You have to move towards skeletal notes. It's very hard to do, especially in the stress of the moment. Mm-hmm. But when I've seen the best advocates, they're the ones who know where they're going, they know what they want to say, and they don't need the page except to remind them if they've missed a point. And that's also is very engaging. That also, it's eye contact. That you're constantly making that physical connection, whether it be through the video camera or otherwise, that you're looking right in the eyes of the three arbitrators, or one arbitrator if it is one, and you're making sure that they know that you're watching them and you want to help them, that you're there to help.
And I guess with the cross-examination, as an advocate, the phrase you don't want to hear from an arbitrator is, I expect this is going somewhere, Mr. Rubins. Yes.
And I suppose no matter who says that, you've done something wrong, because either they do not at all get what you're talking about or what you're asking about, or you've gone on too long with your introductory questions. I think civil lawyers have a quicker tendency to wonder why you're asking the questions you're asking. And one of the more frustrating things is when you've built out a really, let's say, it's bad to call it this, but a sneaky approach to a witness, which will box them in and force them in the end to give you that great concession. And you're halfway there, and one of the arbitrators says, "Oh, I see where you're going with this, Mr. Rubins. You're going to ask him this after that." Please, I'm getting there. But that is just to say, in arbitration, you have to expect that kind of thing. And the quicker you get through your introductory questions and get to the point, the less likely it is you'll be sabotaged by a well-meaning arbitrator.
Yeah, no, definitely. There is always the risk of that. How do you prepare for cross-examination?
Well, it depends on the case. I mean, the first thing is to read the statements, whether it be expert reports or factual witness statements. Read them again, take notes in the margins. And what you're looking for is not questions. And this goes through the entire introductory part of building a cross-examination. You're looking for concessions. So what is it that you think you can convince a witness by your questions to accept, to say yes or no, if the case may be? And so you're looking through the witness statements or the expert reports, underlining, highlighting, and writing in the margins, here's a concession. He's already said something very useful to my case. All I need is to apply it in another context, and that the person cannot say no when he said yes in his witness statement. I just need to shift the context. So I note that and get a list of those concessions, which are categorized in some way by theme, let's say. And then generally my team will help me by also contributing their own ideas for concessions, and we talk about those. And then we build that into a sort of script where the team isn't tasked with telling me what the questions will be, but only identifying, number one, the concession, and number two, the documents that are relevant to compelling that concession. Because the best thing for a cross-examiner is to know that right at his back or her back, he or she has that great document that says exactly the concession that he or she wants to get. It feels so good because you know that it's there and the witness has no idea, and then you can freely ask your questions. One of the most important things about cross-examination as you move through your career is to move away from the script. I'm not saying I always move away from the script. That's the goal. It's something to evolve to, where really what you've got is notes of the concessions and notes of the documents that help you get those concessions. And then effectively you're improvising the questions. Now, some of them you may know a great question to ask, and so you'll sketch it down. Maybe you'll have even a series of 3, and if he says no, then this, and if he then says yes, then this, maybe. But the more detailed your script, the more difficult it is to depart from that script when the witness gives you that unexpected answer. And I've seen many people who are experienced cross-examiners who are tied to a script get that weird answer from out of the blue, and they go, that's not in the script. And there's the deadly pause, and they don't know how to exploit it because they're thinking, but now my string of questions is broken. Right? And indeed, it's the unexpected answer that can give you the opening to get even more of a concession than you thought you would get in the first place.
Yeah, no, it could be either an unexpected answer or a question from a member of the tribunal that takes things in a different direction, that as opposed to the one you were planning on.
Absolutely. And the other point is you may get the concession super early. Right? And I've seen this many times with young cross-examiners, is they've got their questions and they start answering. About 3 questions in, the witness gives them their thing and they keep going because they've got the questions on the page. Yeah. That must mean that those questions have to be asked. And of course, you kind of go in your head, oh, you should really stop now. And it all gets undone afterwards, which goes on to this question, when is one question too many? You've always got to listen. And when you've got a script, you're focused in on reading. You're not listening. You're closed in, and you need to open out. You need to watch the tribunal. You watch the witness, and most importantly, listen to precisely what the witness says. Sometimes it's the opposite. You think that he's giving you your concession, and actually there's a qualification, or the words aren't quite right, or it comes out bad in the transcript or something, and you've got to stop, rewind, and try it again. And if you're not listening, you just let it blow by. I've done it many times myself. You just, I got my ding, I got it, I move on. And then later on, you look at the transcript, I never got him at all. She got away from me.
When the other side's advocate is cross-examining your witness, what can you do to help or protect your witness?
Almost nothing. It's a bit like a like a slow motion train wreck. What you really can do is prepare the witness, not for particular questions, because frankly, A, for many of us, it's unethical to do that. B, I think it's counterproductive. It makes the witness overthink. There are certain basic things that almost any witness can understand. Number one, if arbitration is a football game, you are on defense. You're not on offense. You're not going to score the goal that wins the game. Just get that out of your head. You're not going to win this for the company. Okay, but you can lose it, right? And so getting them in a defensive frame of mind, getting them to do the work, read the documents. Every document has got your signature on it. You read the document. No, you don't flip through it. You read it. And then the basic things. When you're asked a question, don't answer right away. Ask for, look for context. You don't understand the question, ask them to rephrase. So these, just getting the witness sort of comfortable with a limited number of basic rules of behavior can go a long way to making sure that there isn't a train wreck on the day. But if there's a train wreck on the day, the only thing that really you can do is redirect, which is one of the most difficult things any advocate has ever had to do, because you're asking a friendly witness an open-ended question, and you do not know what they're going to answer, and there is no damage control after that. And so it is so easy to get scared, so scared by what's come out of your witness's mouth that you're passionate about getting that redirect without realizing that actually damage control means we're just stopping. We're going to show confidence that this, it doesn't matter. We have no questions to redirect. Thank you. On the other hand, sometimes there are relatively straightforward ways to remind the witness about what he or she actually knows. You know, let me show you this document, Mrs. Jones. Do you recall this document? You were asked this question. Does that give you a little bit of context? Do you remember anything more about that? If you think that'll work, then redirect is effective, but use it sparingly.
Great. Well, no, I know your time is short, so we've got one more bit to do. But before that, any final top tips on cross-examination for our viewers?
Always listen, and again, remember, don't ask that extra question. Now, unless it's a Brown and Dunn situation where there's an English tribunal and you think it's expected and you feel uncomfortable not asking that last question. But I'll just give one quick example, which is a classic example from American litigation training. So there's been a fight, right? And your client is accused of having bitten off the nose of the plaintiff, and there is a witness for the plaintiff who was bird watching and says that he saw that he knows that the nose was bitten off. Right. So that's the question, and you ask him. So, Mr. Jones, you were there on that day, were you? Yes, I was. But you were bird watching, weren't you? Yes. And you were standing in such a position that actually the trees were in the opposite direction from the fight. Isn't that true? Oh, yes, that's true. That's true. And at that moment, there was a blue-breasted warbler in that tree, wasn't there, Mr. Jones? Yes, in fact, there was. It was absolutely beautiful. And that's what you were looking at the moment of the fight, isn't it? He says, yes, that's what I was looking at the moment of the fight. Okay, now, here you stop. But a cross-examiner might say, so how is it possible that you could know, Mr. Jones, that my client bit off Mr. Smith's nose? I saw him spit it out. That's one question too many.
Brilliant. Thank you very much, Noah. The last bit we've been asked to do with all of these interviews is something called 10 by 10. So 10 quick fire questions. Are you ready?
I hope so.
What is your favorite book in Russian?
The Master and Margarita.
Favorite pastime outside of work?
Music.
What was your proudest win?
East Mediterranean gas against Egypt.
Favorite film or TV series about lawyers?
Suits.
Favorite ice cream flavor?
Pistachio.
Do you have a secret skill that people are generally not aware about? What is it?
I can move my ears without without using my hands. Hold on a second.
And eyebrows as well. Brilliant. Favorite
That's my
restaurant?
That's my superpower.
Superpower. Brilliant. What is your favorite restaurant, but not in the city where you usually live?
Oh, that's harder. My favorite restaurant. It's been so long since I've been to a restaurant, I'm stumped on that one. That wasn't
very
fair.
good. Hopefully we can come back to those soon. I'll ask you again in 6 months, and hopefully you'll be able to remember where your favorite place is. But maybe some new one. Which actor would play you in a film about your life?
Matthew Broderick.
What career would you want to pursue if not arbitration?
Diplomat.
And favorite dispute resolution conference?
EEDRF.
Brilliant. Noah, thank you very much for your time, for your great answers and your very helpful tips. And I hope to see you in person in Minsk or elsewhere. Thank you very much.
Thank you so much, Artem. It was a wonderful discussion. Thanks so much.
Bye-bye.